presumption there is that it says if a group of persons come together to pass a law, it doesn't rob that law of its command, because it means we have a group as a command behind the law. But the issue of sovereignty is still there, because you can't have multiples being the sovereign forces behind a law. There must be a determinate person. But in this context, a group constituting the sovereignty is recognized in the argument of positivism. So let's talk about sovereignty briefly. The notion that sovereignty is indivisible is falsified by federal constitutions, and certainly Austin's attempt to locate the sovereignty in the United States was a singularly unhappy venture. Meaning, when Austin attempted to justify sovereignty, his own sovereignty, from the narrow compass of the United Nations, it was pointed out that the constitutional supremacy is actually the essence of sovereignty, not an individual. It doesn't regard constitutional law, international law, customary law, and others as laws. It says they are mere morality, rules of morality. Law and morals. The positivist aspect of the Austinianism, meaning Austin. Austinianism is most in evidence in the rigid separation of law from morals. It means the real velocity of positivism is its attempt to separate law from morals. Most of the critics of this approach will be classified in one way or another as supporters of an external natural law. Much of this sort of thinking is animated by the strong aversion to recognizing some of the franchised output of the Nazi legal system as law. This is to set up some sort of an objective moral law as part of the universe, and involves a relation between objective essential proposition and valuations, meaning oughts. The argument here is that we can't really separate law from morals, as the Austinian apostles will argue. Because any attempt to separate law from morals will mean we are providing justification for the madness of the Nazi Germany. Because we are saying law has nothing to do with morals, then the Holocaust will not be good laws if we don't want to look at law from the moral aspect. But what they did was criminal, was moral. Yeah. So to that extent, scholars or opinion writers says you can't really take Austin or Austinians serious as to what law is, because that will provide a reasonable justification for the madness, the kind of madness of the Nazis. That's an argument. So let's look at the argument on law and sanctions. Austin's insistence on sanction as a mark of law has frequently been objected to as concealing or distorting the real character. Sanction, Austin's insistence on sanction as a mark of law has frequently been objected to as concealing or distorting the real character and function of law in a community. Sanctions, it is said, do not explain why law is changed and place an undue emphasis on fear. The essence of a legal system is the inherent fact based on various psychological factors that law is accepted by the community as a whole, as binding, and the element of sanction is not an essential or perhaps even an important element in the functioning of society. The argument there is this. They're saying, positivists are saying law must be backed by a sanction. And they argue to the contrary that no, it's not all laws that will have the element of sanction. That if you are saying law must have element of sanctions, you are saying law must impose fear in the heart of people. That is not the essence of law. People don't obey law because they fear the consequences of the law. The consequences being sanctioned. A law will still be law, even if no sanction or sanctions are imposed. That's a school of thought. That law will still be law, even if no sanction is imposed. At the close of the 18th century and the beginning of the 19th, the most earnest thinkers in England about legal and social problems and the aspect of great reforms were the utilitarians, meaning before the Austins of this world brought out their own idea. Those who are pushing the frontiers of jurisprudence and understanding of the law were the utilitarians. Who constantly insisted on the need to distinguish firmly law from law as it is and from law as it ought to be. By contrast, at the present time in the country, the separation between law and moral is, according to some, a superficial and wrong notion. The argument was that even Bentham and Austin were utilitarians in the real sense of their worldview in the early 19th century. So to now attempt to separate their work that says, oh, law and moral cannot come together. Said the argument will only be superficial and it will be wrong to say so, because that was the foundation of their argument. Bentham and Austin were not dry analysts, according to some arguments. With the verbal distinction, where cities born but were the vanguard of a movement which labored with passionate intensity and more success to bring about a better society and better laws. Some rose up to defend their argument, say, oh, these people are not really bad though. They're not bad because they're saying law is law, it has something to do with morals. That they actually sought to bring about a better society and better laws that will have the necessary potency for effective and proper ordering in a society. So then some say, okay, if they are trying to bring about a better society through their work and their positions on law, why then did they insist on the separation of law as it is and law as it ought to be? So then that brings us to the argument, and the court say, why are they trying to say law is law as it is? And when you start to look at law as it ought to be, you are bringing in sentiments and moral consideration, and law is not about moral sentiments. So they alluded to one of the writings of Austin, which I quote. And I want you guys to quote. So are you ready?
Yes, sir.
Note and quote this passage we've been using to analyze Austin's argument. And I start, quote, the existence of law is one thing. Its merit or demerit is another. Whether it be or be not is one inquiry. Whether it be or be not is one inquiry. Whether it be or be not conformable to an assumed standard is a different inquiry. A law which actually exists is a law, though we happen to dislike it, although it may vary from the test by which we regulate our approbation and disapprobation. End of quote. That was the phrase that got Austin into trouble. See, the existence of law is one thing. Whether that law is good or bad is also another thing. Whether the law conforms with societal expectations, be it moral or religious or customary, is a separate thing. Whether it does not is a separate thing. And that law wouldn't need to conform to our expectation of what is good or bad. But if a law favors you, it is good law. If a law doesn't favor you, it is bad law. So law doesn't concern itself with our approbation and disapprobation, meaning you approbate and reprobate. Law doesn't care about our inconsistency because law is constant. Some contend that Austin's protest against blurring the distinction between what law is and what law ought to be is quite general. They contend that it is a mistake whenever our standard of what ought to be, or whether the test by which we regulate our approbation and disapprobation. So we can't be considering law from the compass of inconsistency. If you have a law for the Muslims different from the paganist or Christian or what have you, that law at best atone with our subjective orientation of religion or religiosity. But that is not the essence of law. So it disagrees with the notion of law and morality strictly. The law has nothing to do with morality. And that remains his own position. Gray, another scholar, added at the end of the tribute to Austin, he says, he may have been wrong in treating the law of the state as being the command of the sovereign. But his logic stands. Gray's position was that what Austin was saying really made sense, because law might not be that subjective, because it will become inconsistent and unstable. But the error that Austin made, according to Gray, but that he likened law to a command of the sovereign, meaning he cheapened law. He treated law as something less of serious significance. On the other hand, law, the almighty law, be the command of the sovereign. So it means whatever nonsense the current American president says is law. Whatever stupid thing any dictator says is law. All the nonsense that the late Abacha and other leaders did, law. Because they were sovereign and whatever they do is law. He said, no, law is bigger than being the command of the sovereign. Who's that sovereign? Is it not law that put the sovereign there? So the argument continued. So Austin's command theory was then viewed as his weakest link. So and they argue, what is command? What is command? It is simply an expression by one person of the desire that another person should do or abstain from some action, accompanied by a threat of punishment, which is likely to follow disobedience. Commands are laws if two conditions are satisfied. First, they must be general. Second, they must be commanded by what, as both Bentham and Austin claimed, exists in every political society, whether it is constitutional form, namely a person or a group of persons who are in receipt of habitual obedience from most of society, but pay no such obedience to them. They argue that command actually is the essence of positivism, but it is simply an expression or a desire of another person that you have to do this, if you don't do it, punish. Command from parent, command from boyfriend, command from girlfriend, command from the institution, command from the faculty of law, command from the university. And it says two elements. That command must be general. You guys must be in class by 8 o'clock and you are there. That's general. Two, it must come from a person or body of person to another person who must habitually obey. And that person that dictates the command must not comply. Because if I say, go and get this for me, it's not to myself. I'm directing somebody to go and get something done for me. The person will habitually go and get that thing done. So the person dishing out the command must not be obedient to that command. Others, it must command others to be obedient. That is the essence of the command component. The picture that the command theory draws of life under law is essentially a simple relationship of the commander of the commanded, of superior to inferior, of top to bottom. The relationship is vertical between the commanders or authors of the law, conceived of as essentially outside the law, and those who are commanded and the subject to the law. In this picture, no place, only an accidental or subordinate place is afforded for the distinction between the types of legal rules, which are in fact radically different. What they're saying is that the command theory is a structured relationship from the commander to the commanded, from the superior to the inferior, from the one at the top to the ones at the bottom. It's a vertical relationship and essentially it dictates from the commanded. It dictates from the commander to the commanded, otherwise called the subject under the law. So it says law brings about a dichotomous relationship of master and servant, and that in every law, element that command. It's the law that says you guys must come to class to receive lecture. The law must flow from a determinable source. It must command the doing of something like attendance to class. One of the first juries in England to break into the Austinian tradition, Salmon, complained that the analysis in terms of command left the notion of a right unprovided with a place. But he confused the point. He argued first and correctly that if laws are merely commands, it is inexplicable that we should have come to speak of legal rights and powers as conferred or as arising under them. His argument is, if law is a command, if you view law as a command, then, so why would we talk of human rights? Because when you talk of legal rights, it means you have an option. How can the law commands me to come to class? And because I come to class, it's a command. And because it's a command, it is law. Don't I have a right not to go to class? So if you don't go to class, what's the implication? Of course, I have a right to fail. I have a right to fail jurisprudence. So it's no law. Because I have an option to comply with the law or not. Then some will argue that the fact that you exercise the right or you have the right to do or not to do shows there will be consequence. Nobody will sanction you if you don't come to class. It's your right to come or not to come to class. Because you have a right to fail jurisprudence or any exam or any course. You have a right to choose not to go to the law school. You have a right to choose not to pursue legal education again. So, to someone, command might not really make sense because you don't obey law because of command action. Because we always talk of rights, legal rights, and powers. Egerstrom, another writer, insisted that if laws were merely commands, the notion of an individual's right was really inexplicable. For commands are, as I said, something which we either obey or we do not obey. They do not confer rights. They do not confer rights. So it says law and commands are not the same thing. Commands does not give you right. Any command that gives you right is not a command. And if it's not commanding, it gives you a choice or an option, then it's not law. So all this human right thing are no laws. They are best what they refer to as positive morality. Jurisprudence could be confusing naturally, and it's meant to provoke your thoughts. It's meant to get you thinking, oh, is law a command? It is a command because you have to do it. If you don't do it, there is action. So what's a command? A command is something that makes you to do something. So how about law that gives me right? Fundamental human right, right to life, right to this, right to that. Yes, it's law. So are there commands in those ones? No, there are no commands. Okay, so if they have no commands, it means there are no laws. Because in the Austinians' model of law, it is the sovereign that directs and you must obey. It's a command. Other ones, like constitutional rights, international rights, international or local human rights laws, customary laws, are best positive morality that there are no laws. Some have argued you can't really separate law from morality. That's in another context. Any question? Any questions from me?
Yes, sir. Good morning, sir.
Good morning.
Yeah, I wanted to ask about regulations. What will you call regulations? Would you classify them as law or command or right? For example, the code of dressing regulation that the Faculty of Law imposed on us. Would you call that a law or something that gives us right, because we obviously don't have any right to say anything against it? So is it law? Because it's a regulation, it's not law. So do we have a right to go against it or not?
Law is law. Regulation is law if you obey it. If it directs you to do something, it is law. If you don't comply with it, there is sanction attached to it. So in the context of Austinian's argument, regulation rules are laws because they came from a determinable source, the sovereign, which may not be one person, may be a group of persons. And it is directed at the commanded you. And if you don't follow it, there will be sanction. To them, that's law. The fact that it is called regulation doesn't mean it's not law. It's not every law that is law. Some are decreed, some are act, some are convention, some are declaration, some are regulation, some are rules, some are codes. So they all belong to one journal called law. It belong in a category of laws by whatever name or nomenclature, because there are elements of sanctions attached to those. But some may argue that, as I said, that's their own law. Me, I will not comply. Then it means you want to dare the consequence. So the fact that you are daring the consequence does not make it less of the law because of the sanction element. Are you clear now?
Yes, sir. Thank you, sir. Sorry, one more thing. Would this still be law if you don't know your lawmakers? Like you don't know them. They just held a meeting behind your back and just came and brought the law on you. They imposed it on you. Would this still be law? Would it be fair?
Yes, law is not about the fairness, the moral, the rightness, or otherwise of it. Law is law because it is law. So do you know the maker of the Nigerian Constitution? You don't know. Do you know the maker of human rights law? You don't know. Do you know the maker of international laws? You don't know. Do you even know the makers of the customary law? Assuming they are not positive morality. So you don't necessarily need to know the maker of the laws, but it must flow from a determinable source. There must be somebody who gave that law, whether dead or living. So the spirit and letters of the law is always alive, even if the makers are dead. We obey laws that we didn't make. Criminal codes and the criminal laws were made several years. EFC laws was made several years ago. Perhaps even those who passed it have died. Maybe those who signed it have died. Maybe they're still alive. But you go by the dictates of the laws. You know that there's law in existence and that it's being enforced. It commands you to do something or dissuades you from doing something. That's the essence of the law. You don't necessarily want to know the makers. You don't want to pick or choose the aspect of law that you comply with or the one you disobey. In the real context of law, according to Western Augustinians. So let's continue briefly as we wrap up in a few minutes. So the best place to begin any discussion of legal positivism, of course, an American jurisprudence is in the 1940s, when a philosopher called Lord Fuller accused legal realism of being merely a species of positivism. Fuller thought that legal realism and legal positivism were part of the same jurisprudential family tree. Talking of the relationship between legal positivism and legal formalism, or otherwise called realism. Fuller thought that legal realism and legal positivism were part of the same jurisprudential family tree. He thought that the legal realism was a modern American modification to the legal positivism of Jerome Bentham, and John Austin. Quote, we may say of modern positivistic theory that they diverge, may be called the realist view, as represented by numerous American writers. This may represent that direction of legal positivism, which seeks to anchor itself in some datum of nature, which considers what the law's quest of itself can end successfully only if it terminates in some tangible external reality. You are arguing that really legal positivism gave birth to legal realism, and that legal realism just is an attempt to redefine or modify legal positivism because they belong to the same thing. We've seen philosophers and lawyers and judges who try to emphasize reason or the basis of law and why law compels the doing of certain things in society. The principles of classical positivism were developed by Bentham and Austin. The first and most famous principle was the idea that the source of common law is custom. That only method of proving that this or that maxim is the rule of common law is by showing that it has been always the custom to observe it. They are saying that the essence of law is that it is there for us to comply with.
I often talk about companies as if they're, single entities making decisions, taking action. But it's more like our own bodies, as in different organs, specific functions.
That's a great analogy, and legally that's pretty much how it's framed. These parts are called organs of corporate administration.
Right.
And our focus today, as we dig into these source materials, is to really understand the
Can
key
you
ones,
move
the
the person or
primary
remove
ones,
the
and
person?
secondary ones too, that, make a company tick. It's about seeing the internal machinery.
Exactly. We're trying to unpack who actually holds the power to do what.
Whose phone was that? The second principle was that custom itself was the expression of a nation's shared values, or as we might say today, of the public conception of justice. The argument there is what positivism call law is something that has always been there in the circuit. It has always been there. And people are used to obeying it. They are accustomed to following the dictates of that law. And that's a strong argument to reinforce the command theory. That we are used to obeying that law. We're used to doing what that law says. We're used to carrying out the instruction of that law. Every law according to Bentham, Jeremy Bentham, must come from a sovereign. The sovereign you may know, the sovereign you may not know, but that it must flow from a determinable source, and it must be used, or it must have been used to complying with what the law says. So essentially, positivism is a radical view of law. Radical in the sense that it seeks to be somewhat truthful about what law should be. However, it fails to advance its attention to the dynamism of law. Because if you say law is a command, indeterminable, sovereign, all this, all that, command, sanction. So how about the fintech laws? How about sports laws? How about contract laws? And other bodies of laws that have no sanctions attached to it. So are they law? Are they not laws? Jurisprudence is about viewing things rationally and reasoning through an argument. It is not a yes or no endeavor. It is not a yes or no argument. It's an ongoing conversation that we'll continue to have, and still will always have. It's about rationalizing things. It's about thinking through. It's about justifying a viewpoint. It's about taking a position as a rational being. And you're entitled to your view as to what law is or what law ought to be. That's all I can engage you guys with on positivism. As you continue in your readings, you understand better the argument of positivism. So, by the grace of God, I will switch to sociological jurisprudence, hopefully Wednesday, and I should be able to wrap that up in 2 or 3 lectures. So you guys should have a lovely day, and you see you. Bye-bye. Bye-bye, class.